I believe there are summonses that are returnable today. And as of Monday, some of those summonses were adjourned to Friday. But we are back here this morning to deal with landowners' application for that matter, sitting on the 73rd day of the hearing. And before I proceed any further, Council, please take us through this morning.
Good morning, Commissioner. As you have indicated, what's returnable this morning are a number of leave applications listed number 1 through to 10. They are essentially applications identified as number 6, 7, 8, 9, 10, 11, 12, 13, 14, and 15, Commissioner. Now, Commissioner, before I proceed, if I could invite my friend, Mr. Veritimos, to formally enter his appearance.
Thank you.
If the Commission pleases, Veritimos is my name, initials MM. I appear with my learned friends Mr. D. Wood and Mr. E. Lilly for Curtin Brothers Holdings NG Limited and Ballymore number 39 Limited, if the Commission pleases.
Thank you. Council.
Now, Commissioner, the purpose of today's hearing was essentially to confirm the status of objections raised by Curtin Brothers Holdings NG Limited and Ballymore number 39 Limited in relation to all those applications I've mentioned earlier. Perhaps at this juncture I could allow my friend to advise or inform the Commission the status of that, and then we can then proceed with the other matters that are listed for this morning, but essentially allow my friend to deal with the matters relating to the objections as it was essentially his client's objections, Commissioner.
Thank you.
Thank you, Mr. Commissioner. Councillor Sisting. If I could update you, Mr. Commissioner. So the position is, as you'll recall, that my clients, as they're entitled to do, made certain objections to the material filed by the landowners. In the course of the last couple of weeks, there have been discussions and communications between counsel assisting, both counsel assisting and counsel for my clients, including myself, about objections. The landowners were provided with copies of our objections and the written submissions that supported the objections, and those landowners, or most of them, put in written submissions to counsel assisting in response to our objections. And we, as well as counsel assisting, have considered those written responses, and we'd like to make some brief written submissions, oral submissions in reply to those submissions from the landowners. Having said that, fortunately we have got to a position, Mr. Commissioner, where, as between counsel assisting and counsel for my clients, having regard to the submissions filed by the landowners and our submissions, we have reached a consensus position, at least between the council at the bar table today, in terms of what is genuinely objectionable to and what is not. And so what we have done is the landowners in some respects have made some concessions in relation to material, and we've made some concessions in relation to the objections, and we reached a position, at least between those at the bar table, in terms of what is agreed as to objectionable and what is not. And we have sent a letter last night to council assisting, together with a schedule of objections. So I'd ask that if Mr. Wood could provide to you, Mr. Commissioner, a copy of our letter of the 6th of March 2023 from Ashurst, to Council Sisting, together with a schedule dated the 6th of March, together with the written submissions dated the 21st of March that Mr Wood and I signed. If they could be provided through your, Mr Commissioner's associate to you now, if I could briefly explain the position.
Thank you.
Commissioner, I'll now hand those to your associate.
Thank you.
Yes, thank you, Mr Commissioner. Mr Commissioner, you'll see there that there's a letter of the 6th of March 2023 and a schedule of objections, and also some submissions which are dated the 21st of February 2023. The landowners were provided with a copy of our submissions and our initial objections, and they have replied. May I briefly, just orally, respond to the written submissions provided by the landowners? If I could start with the proposition that most of the landowners, if not all, accept that the Commission of Inquiry may only validly consider material that is relevant to the terms of reference or amended terms of reference, and that the landowners have only been granted leave in respect of amended term of reference 1 quadruple D. Mr Commissioner, you have correctly said with respect on numerous occasions that the Commission will effectively not be derailed by looking into matters which are not relevant to the terms of reference or amended terms of reference. And that's, of course, the correct legal position. To do so would lead the Commission into error if it was to go beyond the boundaries or parameters of the amended terms of reference. Further, by way of additional reply briefly to the submissions by the landowners, I draw, Mr Commissioner, your attention to a few things.
Sorry,
The
Mel.
first is... Yes?
Sorry, Mel, just to interrupt you. We are apparently having audio problems. We're not sure if it's on our end or your end. Could you just check your audio, your volume, please?
Right,
We can't seem to hear you properly.
The volume is at maximum capacity at my end. Can you not hear me at all?
Not very clearly.
I can hear what Council is saying.
Can you at least hear me, Mel?
We have a problem.
Yes, I can hear
Okay,
Council
okay.
assisting, and I can hear the Commissioner.
Okay, we can hear you now, Mel.
Right, thank you. Where did I get to when you could not hear Council assisting? Is there a part that you could not hear?
Perhaps if you can just start again, Mel, for completeness.
Right, thank you.
Yes.
Thank you. Mr Commissioner, both Council assisting and Council for Ashurst have had discussions about the objections, and we've narrowed the issues. I just want to check whether you're able to hear me now, Mr Commissioner.
Not really, Mel. You probably need to adjust your microphone, Mel, to bring it closer to...
My microphone's at maximum capacity. On the test, we had a hearing issue earlier on the test.
Yes.
And at your end, the IT people lifted the volume up. Are you able to hear me better now or not?
Yes. Now we can hear you now, Mel.
That's better?
Yes.
So, as I said, at the testing, there was an issue about hearing me, and your IT staff did something at your end. So, perhaps, Council assisting, if you can't hear me at some time, or the Commissioner, put your hand up or something, and I'll stop. So, Mr Commissioner, if I could just start again. So, as you'll recall, there were objections that were made to various material. Are you able to hear me clearly now, Mr Commissioner?
Yes, I can hear you.
Yeah, thank you. There were could still hear me?
Yes.
Yeah, thank you. Thank you. So there were objections made in relation to landowner material. Those objections were provided to the landowners, and the landowners made, or various landowners made, written submissions. Since that time, counsel assisting and counsel for my clients have been in discussions and got to a position where we agree as to what should be objected to validly and what can't. And so a schedule has been prepared, which if I could ask Mr. Wood to provide the letter that was sent yesterday to council assisting with the schedule and
Yes.
our written submissions of the 21st of February.
Yes, that has been provided.
Yeah, thank you. I'd like to say this, that most of the landowners, if not all, accept that the Commission of Inquiry needs to work within the parameters of its terms of reference or amended terms of reference and is not entitled to go outside those parameters or boundaries. The Commission has correctly stated that on numerous occasions. And of course, if the Commission went beyond the parameters of the amended terms of reference, it would be exceeding its jurisdictional authority, and that would of course constitute an error of law. By way of additional brief comments in reply to the submissions, I wish to draw the Commission's attention to a few points. The first is LA number 16 was filed together with the supporting affidavit, both dated the 8th of February 2022. The submission made by LA6 specifically states, and I quote, the affidavit dated 8th February 2022 was filed a long time ago. End of quote. The significance of that admission was that the application and supporting affidavit, or at least one of them, was provided before the amended terms of reference, which included quadruple D. That means that the material that was prepared at that time, over a year ago, could not have had any regard to the terms of reference quadruple D. That is, it was prepared without any regard to the relevance of term of reference quadruple D because it did not exist. That is just one reason why, and partially explains why much of the material is irrelevant. Secondly, the landowner's material has not been formally tendered or accepted into evidence before the Commission, contrary to a number of the submissions. Merely sending correspondence to the Commission or submissions does not make that material evidence. Proper admissible evidence, that is, for example, affidavits, need to be formally tendered and marked as actual exhibits before they become evidence and subject to valid objections. Until the affidavit material is tendered and marked as a formal exhibit without objection, it does not constitute evidence. And you'll recall that there was an objection to the landowner's material and the documents were not tendered as formal exhibits. They were marked for identification purposes to allow objections to be made. So they have not been formally tendered as a formal exhibit, so they don't constitute any evidence. In the current case, thirdly, the objections have been taken before the documents have been accepted into evidence and formally tendered as an exhibit. Fourthly, counsel assisting has agreed with the merits of many of the objections based on basic principles and undisputed principles, including that material must be relevant to the terms of reference or amended terms of reference before they can be accepted into evidence. Fifthly, there's a misconception by some of the landowners' submissions in that the purpose of the submissions on the objections was not to constitute final submissions answering all the terms of reference. They only related to objections to material. Sixthly, some of the landowners now correctly, with respect, concede that some of the matters they objected to should not have been included in the material, as they accept that some of the material was irrelevant. Seventhly, some of the landowner submissions missed the point with respect. They are directed in many respects to the issue of standing, which we've passed that situation. We're past the issue of standing. They had to deal with the issue of objectionable material because of, for example, the lack of relevance or other grounds. Just because someone has standing does not mean that they can put before the Commission anything they want. They can't raise every grievance that they have. They can't put forward any facts that they have unless they are relevant to the terms of reference. So there seems to be a misconception with respect and an error in that some of the landowners consider that because they've been given leave on a particular ground, they can put before the Commission anything they want. And that's, of course, not correct. And, of course, if they were to do that, the Commission would never finish. It would go on for years because it appears that there may be some internal fighting between landowner groups themselves as to who true landowners, customary landowners are. And this is not the province to start determining those issues, Mr. Commissioner. Many of the submissions are not squarely addressed to the objections, but go off on a tangent. With respect, a lot of effort has been made to consider the submissions of the landowners, and Council Assisting has put a lot of effort, both Council Assisting, in considering the submissions. As I indicated, we've now reached a situation where we concede that some of the objections that we made, we're not going to press them, and others are pressed. And at least between those at the bar table, based on proper principles, there's a consensus as to what's admissible and not admissible. And to that regard, we've spoken to Council Assisting about a suggested ruling that could be made by the Commission. And with the leave of the Commission, if we could pass that suggested ruling to you, Mr. Commissioner, through your associate, of what we say the appropriate ruling should be, if that could be handed up.
Thank you, Council. Council Assistant, you have anything to say?
Essentially outlined the position, and we have no objections to the terms of the ruling that has been submitted as proposed to be handed down by the Commissioner. That is the position, Commissioner.
Thank you.
Yeah.
In consideration
Mr. Commissioner, Mr. Commissioner, as part of the ruling, you'll see that we seek to tender, and we understand without objection from Council Assisting, the letter from Ashurst dated the 6th of March 2023, together with the schedule and submissions of the 21st of February 2023. We seek to tender that as Exhibit OBJ, Objection 1. If those documents could be tendered as Exhibit OBJ 1, that is the letter from Ashurst of the 6th of March 2023 to Council Assisting, together with the enclosed schedule dated 6th of March and written submissions dated 21st of February 2023. Those could be marked as an exhibit.
Thank you, Council Euritimus. The Commission have listened tentatively to the issues that have been raised in relation to the objections. And therefore, in consideration to that, as from the point of view of the Commission, I will give a ruling this morning that the objections taken on behalf of Ketan Brothers Holdings NG Limited and Balimo Number 39 Limited to the admissibility of material provided on behalf of landowners as contained in the schedule dated 6 March 2023, being exhibit number OBJ-1, insofar as it records that they are agreed, are upheld, and such material is ruled as inadmissible. That's the ruling from the Commission. Thank you. Council.
If the Commission pleases.
Yes, Commissioner. So that deals with the objections, unless my friend has anything further to add on the objection issue, Commissioner?
I have nothing further, thank you.
Thank you, Council Varitimus.
Yes, Commissioner. And as I understand, what is contemplated going forward now is for the applications to essentially be adjourned to another date, perhaps this Friday, Commissioner, the 10th of March, for hearing, at which time final submissions can be made by the respective parties, and also the evidence that has now been ruled admissible be redacted, so that only relevant parts of the evidence consistent with the ruling is allowed to be formally tendered and exhibited as part of the evidence forming the terms of this inquiry. Commissioner, with that, I will now hand it over to my friend, Mr. Kukipa. I understand there are matters that he will be dealing with in respect to these applications.
Thank you, Council.
Please, the Commission. Mr. Commissioner, there are, in terms of the final submissions, some landowner applications or applicants have actually filed their final submissions and actually spoken to their submissions. I think from memory, I think 3 have actually made submissions, made final submissions, and the balance of the landowners, I've yet to confirm this, but they have also filed, or some of them have filed their final submissions, and are ready to speak to their submissions or make all submissions on a date to be fixed, as mentioned by my friend, Mr. Guerrero. So, Commissioner, accordingly, what's proposed is for all these applications to be adjourned to Friday for mention / hearing. And I say that because we will have to confirm which of the landowners have yet to file their written submissions, and which of them have actually filed final written submissions, that is, Commissioner. So if I may just formally mention the matters on the list, that is agenda item number 1, which is leave application number 6.
Yes.
If this matter could be adjourned to Friday for hearing. Mr. Gagoa's lawyer, I believe, has filed his written submissions and should be able to make all submissions on Friday, the 10th of March, 2023, Commissioner.
I agree with that. I give the direction that Leave application number 6 is now adjourned to Friday, 10th of March, 2023 at 10 a.m. for Manson.
Please, the Commission, if I may move on to item number 2, that is leave application number 7.
Is
Commissioner, if this could be, if this application could be adjourned to Friday as well.
sorry, can you come out again?
I'm asking for an adjournment to Friday the 10th,
Thank you.
2023.
In consideration to that, and similarly, application number 7 is also adjourned to Friday, the 10th of March 2023 at 10 a.m. for Manson.
If I can just, in relation to that, we're concerned that if matters are listed for mention, they may not progress on the Friday, and it's important that we try to, as far as we can, stay with the timetable. Is it possible that if landowner application 7 is ready for hearing on Friday, that it be listed for hearing and not mentioned, because we're concerned that there may be further delays.
You're asking for the hearing
Hearing, not
and
mentioned.
not Manson.
Correct, you.
Council assisting?
Commissioner, yes. Based on, as I explained, at this stage, I haven't gone through the exercise of ascertaining which landowners have actually filed their written submissions, and therefore I wanted to have them set down for mention in the event that I find out that they have yet to file their written submissions. But however, in any event, I'm amenable to the issue raised by Mr. Wood, and if all applications could be listed for hearing, having in mind that we're going towards the deadline really quick. Commissioner, I'd also like to mention that from memory, leave application number 7, substantive final submissions have already been made by these group of applicants. So the reason for having it mentioned, having it set down for mention, is that if I do confirm my understanding, then we can just have the application discharged on Friday. That's one of the reasons why I wanted to have it mentioned have it set down for mention. But in any event, let's have it adjourned to Friday then. Thank you,
Mr. Commissioner.
Already given the direction already. Yes, Council Voritimus.
Sorry, Mr. Commissioner, I note Mr. Kipper's concerns. I think what he intends, and if we could have this understanding, that if any of the landowners have filed submissions and have already been heard, that is already made oral submissions, then they won't be entitled or required to make any further submissions. If any of the landowners have filed submissions and have not made oral submissions yet, then I understand Mr. Kipper's position that if they're going to make any oral submissions, they're to make them on Friday. So that I think Mr. Kipper's program is that all landowner matters will be finished this Friday so that the Commission can stick to the roadmap. But if Council Assistant could clarify that as the overarching intention.
Thank you, Councillor Voritimus. Council Assisting.
Well, Commissioner, like I mentioned, that is the intention behind seeking the adjournment. That is the correct position. We're trying to deal with all landowner applications this week so that we can move on to the summonses the following week and final submissions, of course.
Is your oral submission, is that right, Councillor Veritimus? You mentioned some of the oral submission.
Yeah, that is in terms of any of the landowners who have actually filed submissions in accordance with your directions. Not all of them have, but in terms of those landowners who have filed submissions as directed and have not yet made oral submissions, then those submissions are to be delivered on Friday, noting the further direction that the oral submissions should not exceed 20 minutes in time. So that's what the intention is, so that, as Mr. Kipper correctly said, because of the pressures, time pressures, all the landowner matters are to be finished by this Friday, so it's important that the landowners understand, which I'm sure they do, that if they've filed submissions and they haven't made oral submissions, then Friday is the opportunity to make them.
Thank you, Council. I think we have same view on that. I have already given the direction that the application is not adjourned to Friday at 10 a.m. On the 10th of March 2023.
Thank you, Commissioner. If I could quickly mention the balance of the matters. That is item number 3. That is leave application number 8.
Yes.
Item number 4, leave application number 9. Item number 5, leave application number 10. Item number 6, leave application number 11. Item number 7, leave application number 12. Item number 8, leave application number 13. Item number 9, leave application number 14. And item number 10, leave application number 15. Commissioner, if a similar direction could be given for all these agenda items, or leave applications to be adjourned to Friday for hearing.
Thank you, Council. I'm satisfied with that. And therefore, those agenda items that has been mentioned and the leave application number that have been highlighted is now further extended to Friday, the 10th of March 2023 for hearing. Council? Yes,
Yes, Commissioner.
for hearing. That's at 10 a.m. on Friday. Thank you.
Please, Commissioner, there are no further matters. If the proceedings could be adjourned to Friday. Thank you.
Thank you for your attendance this morning. Until we return back on Friday to deal with all those applications and the submission. I believe that we are on the right track as per our roadmap, so that we don't put any more delay to the timing of what we are going through. Having said that, I believe that our time is coming to an end to wrap up this inquiry. But in so doing, we have to ensure that all our effort in getting things together must be on the right path so that we achieve what has been given to us, and the task is to ensure that the objective of the terms of reference that the government has put forward must be achieved in every respect. With that, I don't have any other matters to deal with this morning. But until we return back at 10 a.m. on Friday, the 10th of March, our society can now adjourn all the matters to the 10th of March at 10 a.m. Thank you.
All right. This commission of inquiry is now adjourned.